last name?
Yes, Matthew Scott, last name spelling Scott.
All right, thank you. Mr. Ziegler, whenever you're ready, please proceed.
Thank you, Your Honor. Trooper Scott, what is your occupation?
I'm a trooper with the Michigan State Police
How long have you worked in law enforcement?
since 2012.
Were you on duty on January 15th, 2023?
Yes,
Do you recall assisting Officer McCormick in a traffic stop early that morning?
yes.
How did you become involved in that stop?
During that time, myself and my partner, we were patrolling within that area, and we had noticed and heard radio transmission over the radio saying Officer McCormick had conducted a traffic stop on Hyde Street near Essex Street. So at that point in time, we decided to go over and assist with the investigation.
Okay. And what happened when you arrived on scene?
At that time, they had already been established within their investigation. And as I was walking, I was seeing a male subject was in handcuffs, being detained, being brought back to the patrol vehicles, and there was a female subject in the driver's seat at that time.
Did you make contact with the female in the driver's seat?
Yes,
And when you approached the vehicle, did you ask her any questions?
I did.
What did you ask her?
Initially, I asked if had anyone given or asked to consent to search of the vehicle, and she said no.
Did she say anything after that?
I did request for verbal consent to search of her
Your
vehicle.
Honor, I'd object to the extent that whatever it was that Ms. Borziak had said is hearsay.
Repeat the question, Mr. Ziegler.
Your Honor, I was asking what the trooper had asked her and what her response was.
And
Right.
my response, Your Honor, is that he had indicated that she had not given him consent, and then there was a follow-up question to that for which I have an objection, in as much as it's hearsay, whatever she said thereafter.
All right, Mr. Ziegler, maybe you can just pick up from where we left off and ask your next question, and let's see if that's objectionable.
Well, at some point, does the driver of the vehicle make some motion regarding the center console?
Yes, she voluntarily opened the center console, stating that I could search in that center
Well,
console.
Again, Your Honor, I object to the extent that whatever it was that she allegedly said, Your Honor, is hearsay. She's not a witness that's testifying.
Your
I mean,
Honor,
at least,
if I could respond, Your Honor.
yes, Mr. Ziegler.
Your Honor, my response would be that it's not offered to prove the truth of the matter asserted. The question in this case is whether or not there was consent. That's a question of whether or not the officer had a reasonable belief that he had apparent authority to search that area. So the statements aren't offered to be whether they're true in and of themselves. They're offered to show whether or not the officer at the time had apparent authority to search that area. So it's offered for the effect on the listener, not for the inherent truth of whether or not he could actually search that area or not.
All right, I'll allow the statements for that purpose as stated by Mr. Ziegler.
Thank you, Your Honor. When she opened the center console, did she make any statement to you?
She did. She pretty much at that point in time, it said, you can go ahead and search in here. There is a knife.
Okay. And what did you do upon being notified that there was a knife in the center console?
I obtained the knife from the center console and examined the knife in itself, which was I guess if you want to describe the knife as a out of the front blade, where it was push activated with a trigger, and it shot the blade through the top of the handle, and it revealed the blade to be double-edged.
Okay. Would you describe that as a switchblade?
Yes,
It was a mechanically activated knife.
correct.
Did you communicate that information to Officer McCormick?
I did.
What happened after you and Officer McCormick were aware of the nature of the knife?
At that point, we agreed to have the female driver exit the vehicle so we can conduct a further search of the vehicle's contents.
And did you then subsequently search the vehicle?
Yes.
What did that search reveal?
My findings at that time, underneath the front right passenger seat, we located a locked black lockbox. And within plain view, with the side of the slit of the lockbox, revealed to be what appeared to be illegal narcotics inside of it.
How are you able to determine that by examining the box?
Again, within plain sight, there was a small crack of that lockbox, and within the eyesight, you can actually see inside of that lockbox, and it had a glass smoke pipe, which appeared to had like a white crystalline substance coating the inside of it. And based on my training and experience, I would identify that to be illegal narcotics.
Was that box locked or unlocked?
It was locked.
And you were able to determine that prior to opening the box?
Correct.
At some point, was a decision made to actually open that box?
Yes.
How was that done?
At that point, with that probable cause, we had accessed a small pry bar from our patrol vehicle, and we opened it up and revealed quite a bit of an unknown amount at that time of suspected illegal narcotics and paraphernalia.
Okay. When you say paraphernalia, was there actually a pipe inside the box?
Yes.
During this incident, were you equipped with a functioning body camera?
Yes.
And would any video recorded by that body camera be date and time stamped?
Yes.
And if there is video of an interaction similar to the one you've described today, date and time stamped from January 15th, starting around 1:45 a.m., would that be your body camera footage?
Yes.
Your Honor, I would move to mark People's Exhibit 1 from our motion as Exhibit 1 to this hearing.
Mr. Seeger.
Your Honor, my only objection,
Hold on, Mr. Ziegler, are you asking to have that admitted?
I am, Your Honor.
Okay, Mr. Seeger.
yeah, excuse me, Your Honor. And Your Honor, the only objection that I would have to the admission of the body camera statements that are made by other parties, and as much as it depicts the investigation that Trooper Scott conducted, I don't have any particular objections to that, Your Honor, but any statements made by someone who is not the defendant, if it's used for the truth of the matter asserted, or the court is somehow considering those statements, then I would object to the admission of those portions. But in terms of just reviewing the body cam in as much as it reflects what Trooper Scott did during the course of his investigation, I don't have an objection to that, Your Honor.
Do you have any response to Mr. Seeger's objection as to statements on that video?
Your Honor, I'm not sure that there would be any, maybe there's some discussion between the officers at some point on the video that might be hearsay. I don't think the court needs to consider any of those statements. The relevance of the body cam is simply what occurred, what the Ms. Borisiak said, which has already been admitted, the nature of the box. So I have no objection to the admission of the body camera with those stipulations as laid out by Mr. Seeger.
Okay, so the court will admit the video as People's Exhibit 1 then.
Thank you, Your Honor. I have no further questions for this witness.
Thank you, Mr. Seeger.
Sure. So Trooper Scott, when so at one point in time, prior to the stop, Mr. Harshman was operating the motor vehicle. Is that correct?
I cannot recall if Mr. Harshman was in control of the vehicle. So prior to our arrival, Miss Jennifer Borziak was in the driver's seat at that time.
All right. And Ms. Borziak was not arrested, correct?
To my knowledge, no.
Okay. And when you arrived on scene, Mr. Harshman had already been secured?
Yes.
All right.
It's
And
in
do
the
you know,
process.
okay. Do you know how long it was before you got there that Mr. Was there any officer that was standing next to the vehicle at the time that you arrived?
When I arrived on scene, it was Officer McCormick with the Kalkaska Village Police, and then Deputy Ray Ferrier with the Kalkaska Sheriff's Office that were on scene.
Okay, but do you know where they were situated? Because the body cam that was provided or is admitted as Exhibit 1 does not show the lead up to your search of the vehicle.
Right. So when just I'll note for the court, when my body cam was activated is when I had just approached the vehicle and made contact with the driver. So at that time, to my recollection, it was Officer McCormick was dealing with the defendant here, and Deputy Ray Ferrier was standing on the driver's side of the vehicle.
Okay. Do you know how much, like, so you said that you heard, I guess, maybe through dispatch or something that there was a traffic stop. Is that correct, officer?
Yes.
All right. And then do you know how much time had elapsed between you hearing that over dispatch and you arriving on scene?
I cannot say for certain exactly how much time. I mean, obviously that is noted through dispatch. But if I would had to put a number, it would just be within a few minutes.
Okay. And then you said that you observed a substance in the safety box, is that right?
Correct.
All right, and that box itself, were there any holes in it other than the crack that you noted?
No, there was no actual holes in or around the box itself.
All right, and so when you say that the box was cracked, what do you mean?
So it appeared if you were looking at the lock container, as I guess at face value there, it appeared like the one side had been smashed down enough where the top container of the lip was overlapping the edge, revealing that side. So if the lockbox, if you were opening it up from the sides, that seal was cracked open just enough where you can actually look inside.
Okay, and the pipe that you found, it was a smoking pipe, is that right?
Allegedly it could be used as a smoking pipe, but yes, that'd be my guess at the time.
Okay, all right, and so possessing a smoking pipe in and of itself is not illegal, correct?
If it's paraphernalia, I mean, just depending on the type of smoking pipe in itself. I mean, that's
Okay,
something that
but I
with
mean,
through training experience with the white crystalline substance with the smoking pipe, I could say that would be illegal. But just possessing a clear non-use smoking pipe, no, that is not illegal.
all right, I mean, you can buy a smoking pipe at any marijuana store in Kilkasket County, correct?
Correct.
All right, and also the pipe itself, like people can smoke all kinds of substances in a pipe, right?
They can, yes.
All right, like, and just in terms of marijuana, people use keef, correct?
They
Are
can,
you
yes.
familiar? All right, and keef is a crystallized type looking substance, right?
Uh, Well, I personally have not much had experience with the substance that you're identifying as.
So you don't have any training or experience with people using marijuana?
With marijuana, yes.
All right, so but you're not familiar with keef?
No, I'm not.
Oh, all right, or any other crystallized substances that are related to marijuana?
No,
So, but your training and experience includes all kinds of different drugs?
yes.
All right, and how long have you been a trooper, Trooper Scott?
I've been with the Michigan State Police for probably a little over 3 years.
All right, and so when you say that you have training and experience, how many stops previous to marijuana becoming recreationally legal or medically marijuana did you, how many times were marijuana, did you make have you ever made an arrest related to marijuana?
I have,
All right, and did any of those people have pipes?
yes,
All right, and were any of those pipes used?
yes,
All right, and did any of those pipes have residue?
yes,
All right. And so it's possible that when you were looking at the pipe that you allegedly saw through the crack, that it could have been residue from another substance?
At that point in time, when I had peered into the locked container, like I mentioned before, there was that glass smoke pipe that was lined with the white crystalline substance, along with other suspected narcotics and paraphernalia inside the container.
Okay, but that's not the question though. Like you weren't able to determine just by looking at it what the residue was in the pipe, right?
From what I appeared, it looked like a white crystalline substance. That's what I identified it as.
Okay, well, I understand that, but you didn't test that prior to opening it, right?
No, I was unable. There's no way I could test at that time.
All right. And you have the ability to do like roadside, like a true narc test, right?
Theoretically, yes.
All right. And you didn't find any, residue on the outside of the box itself, correct?
Correct.
All right. And the driver of the vehicle didn't give you permission to look in the lockbox itself, correct?
Correct.
All right. Mr. Harshman did not give you permission to look in the lockbox itself, correct?
Correct.
All right. And the box itself was locked, correct?
Yes.
All right. And you didn't seek a warrant of any kind to manipulate that box, correct?
Correct.
All right. And you could have sought a warrant if you had probable cause to believe that there was some kind of illegal item in the box, correct?
At that point, we established probable cause with exigency.
Okay. It was exigent for you to open the box at that time?
Yes,
All right. And why was it exigent for you to open the box?
it was from the moving vehicle in itself.
Okay, but I don't understand why it was exigent. So you're saying it was an emergency. Exigent means to me that it's an emergency. Why was the situation exigent?
Well, again, at that point in time, we established that probable cause, and with the vehicle exigency, we determined with my training and experience that we opened up the container.
All right, but you opened up the container with a pry bar, right?
Yes,
All right. And so when you say that it was exigent, it wasn't as if that box was going to disappear, was it?
the vehicle could have, yes,
All right, but the person was detained, right? The driver was detained, right?
the driver at that point in time physically was not, even though it was a traffic stop investigation.
Okay. So you could have sought a warrant then, right?
Theoretically, yes,
All right, well, theoretically, but you didn't, right?
correct.
All right, so your probable cause is based solely on what you allegedly saw in the box itself, right?
Yes,
And you could have, I'm sorry, you could have detained Ms. Borziak, right?
at that point in time, yes,
Okay, all right. And so the vehicle wasn't, the vehicle could have been towed, right? I think that there wasn't a proper plate on the vehicle.
I cannot recall.
Okay. And so Trooper, it wasn't really clear to me. So when I was looking at the body cam, it appeared as though you were manipulating articles in the vehicle prior to asking for consent to search the vehicle. Is that correct?
Ms. Borziak requested for her coat.
Okay, but you were manipulating that coat in advance of asking for consent to even enter the vehicle, right?
I did not search the coat.
Okay, but you were handling the coat, right?
She requested for her coat.
All right, were you handling the coat?
At that point in time, I may have put a hand on it without manipulating or looking with the intent of searching the coat in itself.
Okay, so was she free to touch the coat?
Your Honor,
Yes,
I'm going to object to this line of questioning. I don't see what the relevance is of the officer handling or even searching the coat because no item that would be suppressed was found in the coat. It doesn't have any bearing on the questions before the court.
Well, Your Honor, I guess the only relevance there, at least, and I'm just trying to create a record, is that the officer appears to have been manipulating articles within the vehicle in advance of obtaining consent. If consent was ever given.
Well, I mean, if the driver asked for the coat and he's providing it to her, he's got to touch the coat. So to me, that's consent to touch the coat when she asked to have it. So I think we can move on from the coat.
Okay, thank you, Your Honor. Ms. Borziak was the one that provided you with the knife, right?
She was the one that opened up voluntarily the center console. Yes,
All right, and did she say that there was a knife in there?
correct.
Okay. I don't have any further questions, John.
Thank you. Mr. Ziegler, did you have any follow-up questions?
Very briefly, Your Honor. Trooper Scott, you're familiar with what's called a true narc or some kind of field test for controlled substances?
Yes,
Have you performed those kinds of tests in the past?
I have.
To your training and experience, would it have been possible for you to true narc or field test that substance while it was still in the box?
We could have, yes.
Okay. Did you have one of those tests on you?
I did not.
No further questions, Your Honor.
Mr. Seeger?
No further questions, John.
Trooper Scott, I have a couple questions for you. Do you know whether, and I'm referring to the box that you ultimately pried open and is the subject of this motion. Did you ever inquire as to whether or not that box belonged to either Mr. Harshman or Ms. Borziak?
During the vehicle search, no. It was after the contents. Well, without my recollection, I don't know if that conversation took place when we had found that locked container, but at the same time, when I was looking through, revealing the contents, when we pried it open, it was brought to Officer McCormick's attention, who then continued on with his investigation.
Okay, did you ask for consent from either of them prior to opening the box?
To my recollection, I did not.
Do you know if anyone at the scene did?
I do not recall.
Okay, and then again, you don't recall whether or not either of them was asked if they had, whose box it was, I guess.
I do not recall that conversation at that specific time without reviewing further body cam footage or body cam footage from others.
All right, thank you. Mr. Ziegler, any follow-up questions to those that I just asked?
No, Your Honor.
Mr. Seeger?
No, sir.
Okay. Is Trooper Scott free to disconnect at this time?
Yes, Your Honor.
Mr. Seeger, any objection to that?
No, sir.
All right, thank you, Trooper Scott. You're free to disconnect, but you're free to remain on the line if you'd like to as well.
Thank you, Your Honor.
Mr. Ziegler, any further witnesses today?
No further witnesses, Your Honor.
All right, Mr. Ziegler, anything you'd like to present today by way of oral argument?
Your Honor, largely I would rely on my brief. I think the evidence, including the video, which was admitted, establishes that there was a consent to look into the center console. The driver of that vehicle, Ms. Borisiak, voluntarily opened the console without any prompting, without any direction, without any questions about weapons. She voluntarily opens that console, indicates there's a knife in there. The officer takes the knife, establishes that it is a double-edged, non-folding stabbing instrument, which would be illegal to transport in a vehicle in that manner under MCL 750227. At that point, there's probable cause to believe that there is evidence of a crime in the vehicle. At that time, the motor vehicle exception would apply. Officers are then justified in searching the entire vehicle under the motor vehicle exception. Mr. Seeger was asking questions on direct about exigency and about emergency. Case law clearly establishes that a motor vehicle creates an exigency. This has been case law for quite some time. It's been U.S. Supreme Court case law. There are Michigan cases establishing that. I've cited them in my brief. A motor vehicle that is readily mobile creates an exigency. Officers are thereby justified in searching the entire vehicle for evidence of that crime or any contraband that might be related to that. So their subsequent search of the vehicle, even though it was done without consent, was properly done pursuant to that warrant exception. Additionally, I would note, although I did not cite this in my brief, in response to the court's questioning about the owner of the box, there is a U.S. Supreme Court case, Wyoming versus Houghton, Houghton, which states that when officers are doing a probable cause search of a motor vehicle under the motor vehicle exception, they are justified in searching into any container, regardless of ownership of that container, so long as that container could conceivably contain the evidence that they are looking for. It's a 1999 U.S. Supreme Court case. So that establishes that regardless of whether the box belonged to Mr. Harshman or to Ms. Borisiak or to some third party, officers are justified in searching in that container, so long as that container could contain the evidence they are searching for. Since the container contained narcotics and a pipe, it could also have conceivably contained a knife, a small knife, or some other concealed weapon that may have fit into that box. Also, I would say that once the officers look into there and see a glass smoking pipe, crystalline substances, there's residue on the pipe, they also have independent probable cause to get into that box, which is still in the vehicle. So either way the court wants to look at it, the motor vehicle exception applies to the search of that box, whether it's just because they had probable cause to get into the vehicle generally, or whether they had probable cause to get into that container in particular. The motor vehicle exception applies. The search is justified. Even if it's not, I would argue that the good faith exception applies, and I've detailed that in my brief as well. Thank you, Your Honor.
Thank you, Mr. Seeger.
Your Honor, the only reply that I would have, and this is just in response to the brief that was filed by Mr. Ziegler, is at least the brief that was filed by Mr. Ziegler appears to be prefaced on the idea that law enforcement found a what's alleged to be an illegal knife in the vehicle, and such that the motor vehicle exception somehow applies. First, I would note, Your Honor, if the court looks at the court file and looks at the felony information, you will see that the court or the district court made a determination that the weapons charge was not bound over. So there was no probable cause to believe that the alleged item that was perhaps advanced by the prosecuting attorney's office as a vehicle to allow them to have access to the vehicle and subsequently do a search, that matter was not bound over. So I think that that's their first problem. So when the court makes its own findings, he's not bound over on that, Your Honor. So I mean, like, I guess to a certain extent, what a police officer, quote unquote, believes to be probable cause and what a court later determines to be probable cause, I would probably have to defer to the court's findings, not the alleged good faith belief of the officer. Additionally, Your Honor, when I looked at the body cam, Your Honor, which the court has had an opportunity to review, it does not really appear to me, and maybe it appears to the court, that there does not appear to be a hole in the box such that you can see it. The body cam footage, or at least as I reviewed it, did not look to be very telling one way or another. The officer, based on his quote unquote training and experience, is able to identify certain substances, I guess, but it's strange to me that he's also likewise unable to identify marijuana, which seems to be a much more common substance, which was illegal at one point in time. And you can buy a smoking pipe pretty much anywhere in Kilkaskia County at the local grocery store, at one of the, I don't know, 10 dispensaries that are in Kilkaskia County. And there are numerous different forms of marijuana that are going to leave residue. To what end that is, Your Honor, I guess based on his training and experience, he's not able to identify those things, which I find to be odd, which really goes to my belief that his testimony is not entirely credible. My larger problem, Your Honor, is that the officer pretty much admitted that he could have sought a warrant. And in as much as like the prosecuting attorney is advancing this theory of the motor vehicle exception, I don't see an exigent circumstance because both parties were exited from the vehicle. So if they wanted to seek a warrant, I'm familiar with the process based on my training and experience, Your Honor, and it is not entirely difficult to request a warrant. And obtaining a warrant is probably not entirely difficult. It's just strange that it goes through a detached and neutral magistrate, which in this case, they decided we'll just use a crowbar and break into somebody's item. He also admitted that he could have field tested the substance, for which he did not. No consent was requested or given by any of the occupants in the vehicle. And so I find those to be large problems in whether or not the actual seizure of the box and manipulation of the box was legitimate. I guess I would largely rely on my brief itself, but I do not find the theory of the prosecuting attorney to be compelling in any way. And I guess my larger problem is, you know, we have all these exceptions that the higher courts have carved out, I guess, but like good faith to me means that like you are actually acting in good faith. In this case, it appears to me that they just unilaterally decided that we were going to break into somebody's personal belongings without the benefit of obtaining a warrant, which is not a difficult process for them to execute. The parties were detained. If they thought that there was they had reason to believe that there was probable cause that there was some kind of foreign substance within the contents of that box, presumably, Your Honor, it wouldn't have been difficult to obtain a warrant because that happens all the time. I don't know how many files I have, Your Honor, but there are warrants for pretty much every case that I have, and I have almost never seen a warrant be declined when requested. So I find it somewhat legally disingenuous that the officer is maintaining, or at least that the prosecuting attorney's office is maintaining, that it was somehow an exigent circumstance because no one was going anywhere, Your Honor, and they were in possession of the box. And if the court looks at it factually, if you review the video, Your Honor, I did not see, and the court can correct me if I'm wrong, but I did not see when I was looking at the body cam itself, I did not see this alleged hole or crack in the box such that I could see inside of it. The only thing that I saw later was after he manipulated the box with a pry bar, the contents of that box. And so I would just ask the court to grant the relief that's requested. And I don't generally have any further argument, Your Honor.
Thank you. Mr. Ziegler, any response?
Just very briefly, Your Honor, the defense mentions that the count regarding the knife was not bound over. First and foremost, that has no bearing on whether or not the officers had probable cause at the time they initiated the stop and did the search. Obviously, the officers can't be expected to know what a court is going to rule or not rule in the future. Second of all, there's no evidence or testimony about why that count was not bound over. The court can't just assume that the evidence was not sufficient. There may have been other reasons why that count was not bound over. There's no transcript available to the court. Third, we had testimony today about what that knife was. It was a push open mechanical knife. I would describe it as a switchblade, but a mechanical knife. Officer testified that it was double-edged, meaning it had a blade on both sides. Statute is quite clear that any sort of double-edged, non-folding stabbing instrument cannot be transported in a motor vehicle in the manner it was being transported. So the facts as presented to this court today establish at a minimum probable cause to believe that there was an offense being committed. Whether or not that offense actually results in a bind over or in a conviction or whatever later, that has no bearing on whether the officers have probable cause at the time to do a search. Defense brings up marijuana keef. Even if it's possible that that residue was marijuana keef, and I don't know what that looks like on a pipe, I've never seen that. I'm not a medical expert or a drug recognition expert. The standard is probable cause. It's not proof beyond a reasonable doubt. So the fact that there is a pipe and some crystalline substance in a box, I think that is at a minimum probable cause to believe that there may be narcotics in that box. Finally, Mr. Seeger argues that they could have sought a warrant. The standard is not whether they could have sought a warrant or not. The standard is whether or not a search warrant exception applies. In this case, as I've established, the motor vehicle exception applies. I cited several cases in my brief discussing the motor vehicle exception, the legal underpinnings of the motor vehicle exception. There are numerous cases about the motor vehicle exceptions. Long and short, there doesn't need to be an emergency. There's no requirement that if a warrant could be sought, that a warrant must be sought as long as there is a motor vehicle plus probable cause. Officers are allowed to do a search. It doesn't matter whether they could or could not have sought a warrant in any particular case. So for those reasons, Your Honor, I think the search is justified.
All right, thank you. Again, I did have a chance to review the briefs of the parties and the law that was cited by both. Had an opportunity, of course, to listen to Trooper Scott's testimony here today, and an opportunity to review the entire, again, 33-minute video of the stop. The first question here, I think the court needs to consider is whether or not there was probable cause to search the vehicle. It's clear to me based on the video that the driver of the vehicle did provide consent for the officer to look in that center console area. She lived in an unbound area. And in my view, she clearly gave consent to search that part of the vehicle and inform the officer that there was a knife there. The court finds that the discovery of the knife would provide probable cause to search the vehicle. That knife was clearly contraband under the case law and the motor vehicle exception. If you've got a vehicle that's mobile and an officer has probable cause to believe that that vehicle may contain contraband, then the officer can't conduct a roadside search without a warrant. And that's what happened in this case. We found a double-edged knife that was mechanically operated. That's contraband, where the officer had reason to believe that that was contraband. And so the court finds that that would allow for the search of the vehicle itself. During that search, the officers located this black lockbox. One of the things that stood out to me, and neither counsel really addressed this, but does the defendant even have standing upon discovery of that black box to assert a Fourth Amendment privilege? That's a threshold matter. The defendant has to have a privacy interest in that box to be able to assert that it was wrongfully searched. And that means that the defendant had to have a reasonable and personal expectation of privacy in that box. The factors that the court looks at to make that determination is whether or not the defendant owned the box, whether he had possession and control over that box, whether there was historical use by him of that item or property. Did the defendant have the ability to regulate access to that? And then, of course, generally the totality of the circumstances. And one of the arguments that Mr. Seeger makes in his brief at paragraph 19 is that the defendant denied knowledge of the box and informed the officer that it must have belonged to the previous owner of the vehicle. And part of this traffic stop was the driver and I believe Mr. Harshman both claiming to police at the time that they had just purchased that vehicle. So the defendant can't claim that he doesn't own or possess that box, but at the same time assert a Fourth Amendment privilege to prevent the search of that box. It's got to be one way or the other. Either the box is his and he can assert the Fourth Amendment privilege and make these arguments that he's making today, or it's not his and he doesn't have standing to assert a Fourth Amendment violation. And based on the arguments in the brief, and the officer wasn't clear here today in his testimony about whether or not they had knowledge that Mr. Harshman was denying possession of it at the time. But either way, clearly he's denying possession of it now, or at least for the purposes of this motion. And so if that's his argument, the court finds that he doesn't have standing to assert a Fourth Amendment privilege. If it's not his, he doesn't have ownership of it, if he never had possession or control over it, if he never used it in the past, and then the totality of the circumstances based on an argument that it's not his and it belonged to the previous owner of the vehicle, then there is no basis for him to assert Fourth Amendment privilege. He didn't have a reasonable expectation of privacy in the contents of that box. And so he can't now make an argument that the police shouldn't have searched it. And case law is very clear that he can't assert a Fourth Amendment right on behalf of whoever the owner of that box is. So to the extent that Mr. Harshman would argue at trial that it's not his, there would be no reason to suppress the evidence here based on standing. So the court would deny the motion based on standing. To the extent that it was his, and he is able to assert a Fourth Amendment right with regard to the contents of the search of that box, the court finds that there is sufficient evidence to support a plain view exception here. Looking at the video, I mean, I agree with Mr. Seeger. It's hard from the video to see what the officer could see, but I wouldn't expect that a body cam video would be able to depict exactly what an officer would have not seen in that box through the opening. But what we have is the officer's testimony, and his testimony was that he was clearly able to observe both pipe and a white crystalline substance. The officer is not required to make a positive identification of the substance that's in there. Again, we're just talking about probable cause. There's no need for an officer to try and stick some kind of testing device inside that box to make a positive determination of what the substance is before he can search it. He just has to have probable cause that there's contraband inside. Based on the video and the officer's testimony, they could hear a pipe, they could see a pipe, they could see a white crystalline substance. There was actually white crystalline substance falling out of the box as indicated on the video. And so looking at those circumstances as a whole, based on that officer's training and experience, certainly it could have been other things, but he had probable cause to believe that that was contraband. And so the officer had the ability to open that box at that time. Again, whether or not, and I agree with Mr. Ziegler, whether or not, and this goes back to the initial search of the vehicle, whether or not that weapon was eventually determined to be contraband by a court, or whether it was dismissed as part of a preliminary examination. Again, that's not information that an officer would ever have at the scene, and isn't required to have, and doesn't later invalidate police officers' probable cause. So for all those reasons, the court finds the evidence should not be suppressed, and the court will deny motion to suppress. And Mr. Seeger just asked that you provide an order to the court that reflects the court's ruling here today, either with the stipulation as to form for Mr. Ziegler or under the 7-day rule. And then we also have this I'm sorry, go ahead.
In your honor, and Mr. Ziegler, do you have an objection to me just signing your name with permission, generally just saying for the reasons stated on the record?
Please do.
Thank you, Your Honor.
Okay, and then in terms of the status conference today, Mr. Seeger, did you want an opportunity to talk to your client in light of the court's ruling, or did you want to proceed with any scheduling on either of these today?
Well, Your Honor, I think that when I had last spoken with Mr. Ziegler, there are two files which the court has, but that it's my understanding that we would both prefer to handle the drug case first, to the extent that we're going to go forward with either of the trials. I have talked to my client and he wishes to proceed to trial. That does not necessarily mean that some kind of potential resolution can't be met at some point in time in advance of trial, Your Honor. But to my understanding, currently Mr. Hirschman wishes to proceed. And so if the court dockets a trial date, whenever that would be appreciated. And then the second item would be if the court would give us one final settlement conference in advance of the trial date, that may be helpful as well.
Okay, so that would be as to file 234778, which is the drug charge. So the court will set that for a jury trial at its next available date. Mr. Ziegler, can we do that trial in one day, or are we going to need more than that?
I think we could do it in one day, Your Honor.
Mr. Seeger?
Likewise, Your Honor, I believe it's a one-day trial.
Okay, so we'll set it for a one-day jury trial at the court's next available date. Because Mr. Harshman is lodged, this will be given priority. And then the court will set it for one final status conference at the motion day immediately preceding the trial date. And that will act as a plea cutoff. Mr. Ziegler, anything else I can address for the people today in terms of scheduling?
No, Your Honor.
Mr. Seeger?
No, sir.
Okay, so, and I'll set the other file for a status conference at the same time as the final status conference in 234778. The court will notify the parties of the trial date as well as the final status conference. That's all I have for today. All parties are free to disconnect on this file.
Thank you, Your Honor.
Thank you.